Hi everybody, my name is Gerardo, and today I will be walking you through the topic of courts, and more specifically, the litigation timeline. And while I could just sit here and talk to you through the timeline, I think it is better to show it to you through example. So for that, let me introduce you to Mr. Simpson and Mr. Griffin. We now find ourselves in front of the Simpsons' residence, where the first part of the litigation timeline is about to happen, the event. Here we see Mr. Simpson and Mr. Griffin discussing, and they eventually sign a contract where Mr. Simpson agrees to pay Mr. Griffin 50% of the profits if he takes his gold donut and sells it for him in his town of Quahog. Mr. Griffin agrees, takes the donut, and ends up selling it on his way home at a random truck stop. He sends all the money to Mr. Simpson and asks for his half of the profits, but Mr. Simpson proceeds to refuse, claiming he violated the contract by not selling it in Quahog. Mr. Griffin takes this as a breach of duty and sues Mr. Simpson, creating the event. What follows is the advice of the attorney, where things such as the probability of success, the lawyer's fees, and procedures for the case are discussed and agreed on by Mr. Griffin and his lawyer. We are now witnessing the complaint, where Mr. Simpson has received a complaint containing a caption, a signature verifying the truthfulness of the complaint, and the complaint contains three necessary components: a statement of jurisdiction, a statement of facts evidencing entitlement to remedy, and a request for remedy. What has essentially happened here is a service of process, which is a procedure that varies between states and counties and has the goal of making sure defendants are aware of the complaint. As Springfield is located in Oregon, the main provision to the service of process was the need to have it delivered by a third party, such as the deputy sheriff of the town. Some time has passed, and it is now time for Mr. Griffin to receive that answer and affirmative defenses, which is similar to the complaint, and it simply is an answer to the version of events posed in the complaint. Like the complaint, the answer has a caption, signature, and three elements: a response to statement of facts evidencing entitlement to remedy, a response to request for remedy, and an affirmative defense as to why there is no liability. The complaint and answer together are called pleadings. With the pleadings out of the way, what follows is a discovery, which is essentially the formal and informal exchange of information by both sides. This can happen in a variety of ways, such as interrogatories, mental and physical examinations, requests for admissions, requests for production of documents, depositions, or statements. Discovery can be very lengthy, but in our case, it ends up being easy with requests for production of documents and depositions being used. What comes next are motions that can occur at any point but usually do after discovery. They are essentially requests meant to quickly win the legal issue and often before even getting to court. Some different types of motions include motion to dismiss, motion for judgment of the pleading, motion for summary judgment, motion to compel, or another procedural request for the court. Right before trial, a pre-trial conference occurs. This is when the lawyers for both sides get together, sometimes with a judge, and sometimes with a member of the judicial staff, to talk about trial timing, jury selection, and other procedures for the trial. Finally, it is time for trial, which all begins with a jury selection called voir dire. Once the jury is chosen, the attorneys make opening statements of what they expect to demonstrate through evidence and questions. Then, witnesses are questioned by the lawyers, and only the responses can be used as evidence. After questioning is done, the lawyers have one last attempt to convince the jury of their argument. The judge proceeds to explain to the jury the applicable laws, and then they retire to talk about the case and make a conclusion. It is now time for the verdict, which can be something as simple as a guilty or not guilty, or something more specific, as the right amount of money someone is owed. In our case, the jury agrees Mr. Griffin is owed 50% of the profits. Post-trial motions can occur, and they can be aimed at undoing the jury's verdict, or possibly at asking the judge to reconsider a ruling. Some possible ones are a motion for a new trial, which can be based on a factual issue or rulings of the judge, or a motion for judgment notwithstanding the verdict, which is based on the jury making the wrong legal decision. Next, and nearing the end of the timeline, are appeal rights, with all jurisdictions having at least one right of appeal. The problem is that these are very limited and do not necessarily mean a retrial, so in our case, Mr. Simpson's appeal has been negated. And now, it is finally time for the execution, which is the process by which the victorious party can seek what they are owed. In this case, Mr. Griffin has finally received his money. The litigation process is now finally over. And with that, we conclude the topic of the litigation timeline when it comes to courts. Hope everyone is able to learn something new, and wish you the best of days.